Good afternoon, everyone, and welcome to this local review body for the 18th of March 2024. I am Councillor Bob Braun. I am the convener of the committee, and I'm pleased to introduce this afternoon, my two colleagues. On my right, Councillor Ian James, to my left, Councillor Richard Waters. We are all members of the planning committee, as is required to sit on the local review body. To my far right is Mrs. Leslie Tierney. She is a planning advisor to the LRB. She's independent of PKC and has had no previous involvement with any of the applications on the agenda today. Her involvement only begins when we get the appeal. To my further left is Mr. Jeff Fogg, who is our legal advisor to the LRB today, and to his left is Ms. Jessica Guild from Committee Services. So members, to start with, can I ask, are there any declarations of interest? Councillor James?
None for me, thanks, convener.
And Councillor Waters?
I have no declaration of interest.
Thank you very much. We have the minutes of the previous meeting. As I was the only one present at that meeting, I'm happy with those and will approve those. Members, this now takes us on to the first item on the agenda today, and this is item 4.1. And it is the review of condition 3 on planning permission 23/01202/FLL, which is a change of use of builder's yard to form extension to garden ground and erection of link extension between dwelling house and outbuilding in part retrospect at Woodstock, Dinnies Lane, Comrie and Creef. Mrs. Tierney, if you could introduce the case for us.
Next slide, please. So this is the application site, which is the subject of this, the review of the removal of condition 3 on this permission in Comrie. So the application site is outlined in red to the middle of the screen there, with the properties, the existing house and the outbuilding, which are to be linked with an extension, and the area in grey, which is largely about half the site within that red line, is the area of ground which would be changed to garden ground as part of the approval. Next slide, please. And then this is just an overhead aerial map, so you can get your bearings in terms of where the property lies within Comrie, with the river there and the bridge, and then on the main street and up to the back there towards where the old railway line was. The yellow star is the site, by the way. Next slide, please. So in terms of the actual the aerial view here, so you can see the application site. The site is marked with the word site, and again you can see to the top of the lettering there where the existing buildings are, and the former yard area is underneath where that wording is, and that would be what would become the garden ground. And to give you a bit more context, St Keswick Square that you can see off Drummond Street there is to the southeast of the site. Next slide, please. And again, this is just a closer aerial view there of what's within the red line within the application site, the existing house there, the outbuilding, which would be converted and linked with the extension, and then the former yard, builder's yard area to the southeast there that would be changed to become garden ground up Dinnies Lane. Next slide, please. And if you are looking for the site from the main road and through St Keswick Square, you can see across the back there where the existing house is. You can't really see the outbuilding, but the yard area would be to the front there. Next slide, please. And then some of the plans that went with the application and the approval. Again, this is really just the site plan, the existing site plan showing the existing house and outbuilding, and then the rest of the application site being the former yard area that would become garden. Next slide, please. And then this is the layout plan for the existing house and the conversion of the outbuilding, and you'll see there with the linked extension between the two existing buildings. Next slide, please. And then just some elevations to give you the context of that. And the extensions marked there with the kind of blue colouring and the dark areas between the two. It's a small link extension between the two existing buildings. Next slide, please. Next slide. No, is there no more? Okay, that's fine. That's enough for now then. So I'll just run through the case for you. Introduction and background to the appeal. The appeal relates to a condition placed upon the full planning permission for the change of use of the builder's yard to form extension to garden ground and the erection of the link extension between the dwelling house and the outbuilding at Woodstock, Dinneys Lane, Comrie. An existing traditional dwelling house is within the site and an existing outbuilding which will be connected by the link extension. The site is in the conservation area in Comrie and the surrounding area is a mix of housing and commercial property. The principle of development was acceptable and approval was granted, subject to 3 conditions, including condition 3, which this appeal seeks to be removed. And that condition states that development shall not commence on site until an evaluation for the potential of the site to be affected by contamination by a previous use has been undertaken, and as a minimum, a preliminary risk assessment phase 1 desk study has been submitted for consideration and accepted by the council as planning authority. If the preliminary risk assessment identifies the need for further assessment, an intrusive investigation shall be undertaken, and it lists the measures there that would need to be covered by that. The requirement for this condition was as a result of the consultation with the council's contaminated land team, who stated that as the site is a former builder's yard and there's also a former railway to the north, that a contaminated land investigation should be secured by condition on any approval, as there is a potential for the extended garden ground to be impacted by these former activities. So the applicant's case, in this case, I'll try and summarise it as briefly as I can. There's quite a lot of information in the papers. They've provided a variety of justification for the removal of the condition, looking at each of these in turn. One, that the area that is to change to garden has already been used as a garden and parking area for at least the last 6 years, 4 of those under the ownership of the previous owner. 2, there are houses on and next to the former railway line and a primary school nearby, and concern about the proximity of the appeal site is overly cautious. 3, the difference in how the 2 areas of ground in the ownership of the applicant has only come to light since the planning application was submitted. The applicant is under the impression that when the property was sold to them, it was all residential use, despite the historical use of the bottom area of ground as a builder's yard in the past. 4, the property was sold to the applicant in 2022. The previous owner was a builder and they were gifted the land from their father before them, who was also a builder. Locally, it is suggested that the yard was never an active builder's yard and was only used for dry materials, and no chemicals or liquids were stored at the site. Any such uses were off-site at other premises in Comrie. 5, the property inquiry certificate indicated no environmental problems. 6, with regard to the old railway line, this closed nearly 60 years ago and there's development all along this. So to say that the line is to the immediate north is an overstatement, as their house is separated from the old line by a lane and another house. It is unfair under new regulations to now say that the development requires a study to be undertaken when so much development has not been required to. 7, the benefits of the proposal outweigh the need for the study, as the converted building could be used to provide much needed accommodation. 8, they have already put considerable time and effort into turning the sterile former yard area into a natural garden. 9, the proposed extension footprint is small and none of it is close to the former builder's yard area. And 10, the cost of carrying out the study is prohibitive. So consultation-wise, obviously the main one in this case was with the contaminated land officer. They have provided further comments on the appeal, and the applicant has responded to each of those as well. So I'll run through these. So the officer stated that the change of use of a builder's yard is a potentially contaminative past use. Depending on the type of activities formally carried out, there is the potential for contamination to be present from sources such as underground or above ground fuel storage, asbestos, or building supplies or timber treatment products. The applicant responded to say that only sand, gravel and paving stones were stored there in open bays with concrete bases and there was no asbestos. Fuel was never stored in the builder's yard above or below ground. Timber was stored in very small quantities and the main storage area for timber was on Monument Road in Comrie. The officer stated that the change of use to a residential garden also makes the proposal high risk due to the end user being long-term human occupants, to which the applicant responded that the area would seem to be high risk only if contaminants were used there, and we know they are not. People have lived in the current house since at least 1992, and since 1996, when the previous owner acquired the house, the boundary between the two properties was an ordinary fence that would have afforded no protection from the types of potential contaminants mentioned. The officer says that as we do not know the long-term extent that the future garden ground will be used for, any residential garden ground must comply with the soil parameters for residential with garden end use, the most sensitive soil parameter, regardless of whether the garden will be used to grow food for human consumption or not, or be covered with grass or be under grass. To which the applicant responded that they don't want to contradict that. However, the ground is alluvial, comprising impacted pebbles and small rocks for considerable depth. Topsoil has to be imported, and can a list of the contaminants that harm after 35 years be provided? The officer comments that historic permission 05-00868 to the immediate south of the site was also conditioned due to concerns regarding potential contamination from an underground tank. Although there's no information available on this, there is the potential for any leaks or spills from this to have impacted in the vicinity. To which the applicant responded, there is another garden between the appeals site and the former garage site. The ground was decontaminated and purification of the condition was fulfilled as part of the neighbouring development. No one seems to have a copy of the contaminated land report, and why would this be kept for that length of time, or why is it reasonable to ask the applicant to pay money for a report into the same matter when actually testing the soil could be cheaper? Other documents are provided to show what was done, including the waste transfer note for removal of fuel tanks and ground decontamination. The officer commented that due to the lack of information regarding the former builder's yard, a precautionary approach is required to ensure the site is suitable for the proposed use and to safeguard the health of future site users. To which the applicant responded that they do not disagree. However, can the LRB consider the testimonies of various people and the likelihood of harm from the certainly almost likely probability of contamination against the benefits, and consider the arbitrariness of requiring costly exploration for a small area that has long been lived around with no such requirement. The applicant is also now asking some questions arising from the comments of the contaminated land officer. One, the potential contamination from the disused railway is not mentioned. Number two, how will a desk study answer the questions the contaminated land officer cannot? Would it be more cost effective to test the soil directly? 3, government information says your local council will decide if a site is contaminated land. So can you explain why they were directed to a private investigative firm? 4, at what point in this process does the council or SEPA decide how the land should be cleaned up, and who pays for the investigations that lead to this decision? And to what extent are my lawyers or the applicant's lawyers or house vendors responsible for misinformation? 5, does the applicant have to do the study if they don't do the extension to the house? And 6, the applicant was not told that the study would be automatically triggered by submitting a planning permission request together with application for change of use of the land, and had the agent and the applicant known that, then they would have had the opportunity to rethink the application. Thank you.
Thank you, Mr. Chair. We'll open up for questions. Councillor Waters, any questions?
Thank you, convener. Just in relation to the condition and the process, the condition does kind of ask specifically for a phase 1 test study, but can we just get a bit more detail on the actual process and a bit of ifs and whats would happen, i.e. if the death study came back and said there didn't look like any preliminary any risks from contamination, that would be it. And then what would be the subsequent stages if the death study said that there potentially was risks? Thank you.
Thank you, Councillor. It's effectively a two-stage process, where the initial kind of study that's done is really a desktop study, so nothing invasive per se. And if that identified that there was the potential for further contamination, then yes, you know, the further investigative work and the actual remediation of the site would be required. So at this stage, if the death study identified there was no further requirement, then there wouldn't be any further work to be done, but there's still the requirement for it to be done in the first place at the first stage.
Thank you. That's me. Thanks.
Councillor James?
No, the only question I had is what's already been asked. Thanks, convener.
Just a slight one from me, and it may be stretching your knowledge a little, but contamination can spread through land over a period of time. I know we're talking about, it was a comment I hear, there was some contamination in the house, one house away, if that makes sense. But that can still spread through, if I'm right. I know it's limited knowledge for you, but I'm on the right track.
Yeah, I mean, convener, I am no expert, but what I would say is that, you know, they have explained that there was studies and remediation done at a neighbouring site, and that was all signed off and everything was acceptable. But that's not to say that there couldn't have been some leakage elsewhere.
Thank you very much. That's my questions over. So members, can we proceed to determine the application for review on the basis of the information before us, that is the information contained within the papers and the presentation by the planning advisor, or do we require more information? Councillor Waters?
Happy to proceed.
And Councillor James?
Likewise, convener.
I'm happy to proceed as well. So I've read through all the paperwork here. The concept of a contamination report is a standard policy in situations like this. And having read through, I appreciate that the risk is minimal, but it is a precautionary requirement, and I think it's right to have a precautionary requirement here. There's an element of risk, obviously, albeit small, for the applicant. And whilst they may be prepared not to worry too much about it, I think we would have to. And given that, and I note all the comments, and I note various comments from local people, but it is hearsay. So I feel on this occasion I'm going to have to refuse the appeal, and the condition will have to remain in place. Councillor Waters.
Yes, I fully agree. Where I've got some sympathies over the concern over, you know, potentially escalating costs here. I think it is important to understand if there is any risk of contamination, and to have that reassurance that there hopefully isn't any, and that the application can just proceed without any more invasive stuff. But I still do feel it's important that that condition remains within the application. So I agree that we refuse the appeal against this.
And Councillor James.
Thanks, convener. Not a lot I can add to what you've both said already. Again, huge sympathies, because, you know, any cost implication to something that doesn't appear in the first instance to be necessary. However, it's conditioned for a good reason, and anecdotal evidence is never good. So a desktop study at the minimum, I think, is not an unreasonable ask. So like yourselves, I'd go along with your decision, convener.
Thank you for that. Mr. Fogg, a unanimous decision on this one? A unanimous decision to refuse. Okay, I'm sorry, we have to refuse that appeal. Thank you. So members, we'll now move on to item 4.2 this morning, which is the change of use from a flat to a short-term let accommodation unit in retrospect at 5 Gary Place in Toberaragan. I think that's how you pronounce it, Road, Pitlochry. Mrs. Tierney, if you could introduce again.
Thank you, convener. Next slide, please. So the application site is denoted with the yellow star there in the top of the aerial image, so you can get an understanding of its location in relation to, I suppose, Athol Road, mainly the main road through Pitlochry, and then up the hill there, and then you take a right to go along Toberaragan Road. Next slide, please. This is the site plan for the application, so the site itself outlined in red, which includes the appeal property within the building and the access to the building, the vehicular and the pedestrian access into the building, and where the parking and bin storage area is. Next slide, please. And then the floor plan of the property, 2-bedroom flat there. On the ground floor of the building. Next slide, please. This is Toberaragan Road. So this is as you look towards the application site on the right-hand side of the image there. So you can see the road immediately outside the development. Next slide, please. And then this is from the front door of the property looking back towards the main road. So you can see the garden area, the parking and bin area, and some of the other development to the left-hand side there. Next slide, please. And then this is the property itself, all flatted property, and the appeal site is the left-hand side of the image there is a 3-storey element. The appeal site is as you come into the next 2-storey element on the ground floor. Next slide, please. Again, this is just a closer up image of that property there. Next slide, please. And then this is just taken further back so you can see the parking area and the access in to the property and some of what's round about as well in terms of other residential property. Next slide, please. No more. I'll move on to the presentation. So yes, this application is for a change of use of a flat to short-term let accommodation in retrospect. The 2-bedroom ground floor flat is part of a flatted development. There are 4 other flats in this block which are accessed from the same communal entrance. There's 1 designated parking space for the flat and a communal bin area. The Council's non-statutory planning guidance on short-term lets was approved on the 1st of November 2023 and is a material consideration, and this application was determined after that date, and the appeal can be proceeded with. The guidance outlines matters to be considered in the assessment of planning applications, including whether the property is within a predominantly residential area and there could be an adverse impact on amenity for existing residents, particularly in blocks with shared or communal entry. It also states that proposals must comply with all relevant LDP2 policies, in particular Policy 1 placemaking, which states that development must contribute positively to the quality of the surrounding built and natural environment. The guidance acknowledges that while short-term lets can bring economic benefits to the host and local areas, this must be balanced against the impact the loss of that residential property has on the availability of housing for local people, and in particular access to affordable housing. So the reasons for refusal were, firstly, that the proposed change of use is contrary to Policy 30 Tourism E of National Planning Framework for 2023, as the proposal will result in an unacceptable impact on local amenity and character of the area, and the loss of residential accommodation where such loss is not outweighed by demonstrable local economic benefits. And secondly, the proposal is contrary to NPF 4, Policy 14C, Design, Quality and Place, and Perth and Kinross Local Development Plan 2 2019 Policies 1A and 1B Placemaking and Policy 17D Residential Areas, as the short-term let accommodation would adversely impact on the amenity of residents and the short-term let use is not compatible with the amenity and character of the surrounding predominantly residential area. So the assessment of the application by the planning service stated that the flat is accessed from a communal entrance which serves 4 other flats. There are other private flats in the development, and the short-term let could erode the residential character and amenity on a cumulative basis, and is therefore incompatible with the block of 4 flats and the established surrounding residential development. The short-term let use and movement through the turnover of guests will have a detrimental effect on existing residents and an associated adverse impact on the safety and perceived safety of those residents. The intensification of use and movements and the potential for noise would adversely impact the amenity of neighbouring residents and would alter the private residential character. Any measures put in place to manage and control bookings would not guarantee to stop or prevent antisocial or noisy behaviour occurring or from impacting adversely on the amenity of neighbouring residents, and this matter could not be easily controlled by planning conditions. In respect of the contribution to the local economy from one property in use as a short-term let, this would be limited, and the loss of this 2-bedroom residential flat is not outweighed by demonstrable local economic benefits. The Communities Housing Strategy team state that the postcode district level of potential short-term lets is above the level at which it may be considered appropriate to introduce a control area in order to manage high concentrations of STLs where it affects the availability of residential housing or the character of a neighbourhood. So turning to the applicant's case, they've stated that when they inherited the property, they saw it as an opportunity until such times when they will be retiring to the property. And they've been born and brought up in Pitlochry, and that the neighbours are happy and that short-term lets are beneficial to the local economy. So just some other matters. There's obviously a dedicated parking space associated with the property. The application site is also within convenient distance of public transport in terms of bus stops and the railway station. One letter of objection stating that it would be of no benefit to the town where there is actually a need to keep housing for staff for local facilities like the hospital and theatre, and it will exacerbate housing shortage. Thank you.
Thank you. I'll open to questions. Councillor James.
No other questions from me, thanks, convener.
And Councillor Waters.
Thank you, convener. Just confirm that this does have a communal access into it.
Yes, sorry, councillor. It is. It's a communal access to. They're on the ground floor, but other properties are accessed through that communal access door.
And is that generally a locked door with a fob or something?
They're generally only able to be opened by the owners of the properties. And what happens with a lot of the STLs is there's a key box or something on the wall outside where visitors would access the key for the property.
Thank you.
And I have no questions on this one. So members, can we proceed to determine the application for review on the basis of the information before us? That is the information contained within the papers and the presentation by the planning advisor, or do we require more information? Councillor James?
No, happy to proceed, convener.
Councillor Waters?
Happy to proceed.
I'm happy to proceed. So Councillor James, could you start us off?
Yeah, thanks for that, convener. These cases are so difficult, and you're torn, or you're between a rock and a hard place. Every bit of me wants to say yes, go ahead and do it, because you know the owners are actually in a tied property with their job. They obviously don't want to sell a property and come off the property market. They want to keep their own, but by the same token, they don't want to leave it empty. In this case, the residents or the other 4 residents of the property are quite happy with the current arrangement, and every breath body seems to agree with them that, you know, that they don't have an issue with it. However, looking at the other side, all of the policies and advice that were given sort of leads us down the road to refuse the appeal on the grounds that, you know, it's a single entrance to the property, it's in a residential area. Do you know, it's a real difficult one. I'm minded to actually to allow the appeal and for them to continue use the short-term let convener. I don't think, you know, if we weren't to allow this, I don't think it would bring another property back onto the market. And I don't know, it's a rock and a hard place, but I'd be minded to grant the appeal.
Thank you, Councillor. I'll take the next decision. I understand where you're coming from. I do honestly understand, but we are looking at one policy, which is NPF 4 policy 30, paragraph E, and the core of this really is local amenity and character. That's the central point of it. And as Mrs. Tierney's mentioned, we also have as a material consideration the appeal to the Scottish Government, the DPEA, although it's in a different location. It relates very much to the same sort of property. And its amenity is the point here, and I think it's quite clear from that and from the communal entrance here that much of the problems apply. And although there's been no complaints from anybody, I accept that. The impacts on amenity and character are not limited to recorded instances of complaints, and that's made clear. Also, the movement of people, and that includes luggage and vehicles, can give rise to a situation where there's an intensification of movement, which would not be normal in a normal residential area. The property is residential, there's no doubt about that. When you see the photographs of it, I've seen it myself. And a short term, that is effectively a commercial operation. So it's a commercial operation within a residential area. So all things concluded, and whilst I do appreciate where you're coming from, and I do have sympathy for the people, particularly in this instance because of their existing accommodation arrangements, I feel that with the information we have and the material considerations, I'm going to have to refuse the appeal. Councillor Waters.
Thank you, convener, and I think my comments would reflect your own almost word for word, and while I do have sympathies over the current situation and potential future situation, the policy is quite clear regarding residential areas. So I again will refuse the appeal. Thank you.
Thank you very much. Mr. Fogg, we have a 2-to-1 majority on this one. I think that Councillor Watson and I are going with the actual reasons for refusal as they are. I'm not sure if looking at number 2 where the policy 1B applies, you might want to look at that, but
thank you for that. Where at least one of the agents this morning has pointed out 1B in his view was not relevant to a short-term let application. When one looks at the wording of background policy 1B, I have to say I concur. I believe that's Mr. Tierney's view too. Therefore, if you are otherwise minded to sustain the refusal, my advice is that it should be under deletion of the reference to background policy 1B.
I think so, yes, that's fine. So it's a 2-to-1 then on this one.
Yeah, I'm happy with that.
Okay, thank you very much. So members, will now move on to item 4.3. Now, item 4.3, before we get involved in the Mrs. Tierney's presentation, item 4.3 and in fact item 4.4 are both change of use regarding short-term lets. Now, in each case, I've noticed that the dates of paperwork involved in item 4.3, the decision notice was issued on the 27th of September. And on the item, which is 4.4, both flats in the same block actually, was also issued on the 28th of September. Now, the non-statutory guidance that we have didn't come into play until the 1st of November. So members, I'm of mind that this should be deferred I think in fairness, it's a means we've carried out before. And I think really we should defer this back to the planning officer to assess if there's any change in his views based upon not statutory guidance, then have that change thought passed to the applicant for them to have their chance to comment before it comes back to ourselves, or back via development management to ourselves. So may I ask, are you both in agreement that we would defer items 4.3 and 4.4? Councillor James?
Yeah, that makes complete sense.
Councillor Waters?
I'm happy with that, convener.
Thank you. So, Mr. Fogg, we're going to defer both those two for reassessment by planning and the applicant. Okay. Members, that now leads us on now to item 4.5. This is a change of use of flat to form a short-lived accommodation in Park Gardens, 26 World Bray in Pitlochry. Back to Pitlochry again. Mrs. Tierney, if you could introduce this one for us.
Yes, thank you, convener. Next slide, please. So again, just to give you an overall impression of the location of the property in Pitlochry, with the yellow star there, you can see actually Tober Argon Road just at the bottom of the slide there. So we're not a million miles away from other appeals and applications we're considering. Next slide, please. In this case, this is the application site here. It's outlined in red there. The areas in blue are small areas of ground in communal ownership there. Next slide, please. And this is the floor plan of the property, an access door which is separate, it's not communal, through to an extension on the side with a kitchen and bathroom, and then the lounge, dining and bedrooms as well. Next slide, please. So again, this is the main road along to the property. Next slide, please. And then here we have the building, which contains 4 flats in this location. You can see the extension on the side of the building there is where the kitchen and bathroom area are, but you can see that from the main road there's a gate and steps that take you down to the ground floor. The upper floor flats are accessed, as you can see probably better on this slide, a deck access to the upper flats from the main road, and you can see the steps down to the front door of this property. Next slide, please. This is taken from the other side of the road, but you can't see the appeal property here. It's obviously at ground floor level. This is the upper two flats with the deck access there. It gives you an impression of the kind of residential area that we are in here. Next slide, please. And then this is just a slightly closer up photograph of the access down to the property and the upper floor properties, and just slightly in the distance there you can see a blue sign which is for a youth hostel. So it's residential, but there is a youth hostel up there. And then this is closer up, walking down the stairs towards the external area, the front door of the appeal property. Next slide, please. And this is on the other side of the building, so effectively a mirror image of what you have on the other side, with the small extension on the side of the property with its own separate access as well. Next slide, please. And this is just the access around the side of the property to the rear garden area. Next slide, please. And then this is as you come round towards the back of the property. You can see the rear of the side extension there, a small patio area and the gardens. Next slide, please. And then just another view there, looking back towards the street. Next slide, please. And then this is just a photograph of the property from neighbouring flats and communal parking and garden area. So the application is for change of use of flat to short-term let accommodation in retrospect. It's a 2-bedroom flat, part of a Victorian stone-built property, which has been converted into 4 flats. The flat is located on the ground floor and has its own external front door, access down a flight of steps from street level. While the upstairs flat at number 30 benefits from a certificate of lawful use for short-term let, the applicant is a new owner of this property and is unable to verify through a certificate application that the use of an STL is lawful, and hence an application for permission was submitted. The other ground floor flat at number 24 is accessed in a similar separate way to the appeal site, being down a set of steps with its own front door, and the 2 flats upstairs share an entrance. Council's non-statutory planning guidance on short-term lets was approved on the 1st of November 2023 and is a material consideration. The application was determined after the 1st of November and therefore this appeal could be determined without deferral. The guidance outlines matters to be considered in the assessment of planning applications, including whether the property is within a predominantly residential area and whether there could be an adverse impact on amenity for existing residents, particularly in blocks with shared and communal entry. The guidance acknowledges that while short-term lets can bring economic benefits, this must be balanced against the impact the loss of that residential property has on the availability of housing for local people, and in particular access to affordable housing. The reasons for refusal with this application were that the proposed retrospective change of use is contrary to Policy 30, Tourism, E of National Planning Framework for 2023, as the proposal will result in an unacceptable impact on local amenity and character of the area, and the loss of residential accommodation where such loss is not outweighed by demonstrable local economic benefits. And secondly, the proposal is contrary to National Planning Framework 4 Policy 14C, Design Quality in Place, and Perth and Kinross Local Development Plan 2, Policies 1A and 1B, Placemaking, and Policy 17D, Residential Areas, as the short-term let accommodation would adversely impact on the amenity of residents, and the short-term let use is not compatible with the amenity and character of the surrounding predominantly residential area. In this case, the assessment by the Planning Service noted that the proposed use has the potential to result in noise affecting neighbouring properties and that harm to amenity could arise even if there were effective control. It references the Burnham appeal decision, and that any measures put in place to manage and control bookings would not guarantee to stop or prevent antisocial or noisy behaviour occurring or from impacting adversely on the amenity of neighbouring residents. This matter could not be easily controlled by planning conditions. This is despite the proximity of a youth hostel 100 metres to the west. It is also noted that the benefits need to be balanced against the loss of that residential property on the availability of housing for local people. The applicant's case in this appeal, that the property has its own front door entrance many metres away from other entrances to the block it is part of. It has been let out via Booking.com and Airbnb are the 2 examples given since May 2022. That no antisocial behaviour from guests has been reported. There are no hot tub or barbecue facilities, and guests are prohibited from these activities as a condition of their stay. That a maximum of 2 guests at any one time can stay there, and no children or infants are permitted to stay. The property was previously used as a holiday home for more than a decade prior to their purchase of the property in December 2021. The appellant has also copied other papers that they wish to draw out in their appeal, other council papers in support of their appeal for information, the STL evidence paper, Pitlochry infrastructure report, and Perth and Kinross fact sheet 2019 with reference to tourism and visitors. And then just in terms of some other matters, there were no letters of objection to the application. Environmental Health has no objection. The roads team has no objection as there is on-street parking available and the site is also close to public transport. And the Communities Housing Strategy team noted that the postcode district level of potential short-term lets is above the level at which it may be considered appropriate to introduce a control area in order to manage high concentrations of STLs where this affects the availability of residential housing or the character of a neighbourhood. Thank you.
Thank you. We'll go to questions. If I may, I'll start this one. There is another short-term let in the same block Just to clarify, is that in the same end as the one we're looking at? In other words, is it above it?
Just bear with me, convener. So this is number 26. The upstairs flat with the lawful use is number 30. So I suspect it's not. I suspect the upstairs flat is 28. Well, the other ground floor flat is 24. 24, 26. I'm afraid I can't tell you for sure, convener. It may be more apparent on one of the images.
I don't think it says in the actual paperwork. I'm just trying to find the things here about it. It does mention there's another one there, but
Can you go back to the floor plan, please? And the next one. Doesn't help.
that's fine. It's fine. I found it. There is a flat above, number 30, that also operates as a short-term let. So the question's answered. Fine. Okay, thank you very much. Solved it. Solved it. Councillor Waters, any questions?
Three questions, please. First one is you mentioned a couple of times about the youth hostel being in the vicinity. Is that set aside in a more secluded way, or is it connected to other buildings?
Sorry, I missed the start of that question, councillor.
You mentioned the youth hostel in the vicinity. Is that kind of set aside building? Is it or is it joined to any other buildings? Is it detached or?
From my recollection, councillor, it's a standalone property. You know, just a few yards along the road, on the opposite side of the road, as you head towards the town centre. So although this is a residential area largely, and it's not far from the town centre, the youth hostel is really in between the edge of the town centre and this area, this more residential area.
Thank you. And in relation to the, you mentioned, and it's in the papers, that the applicant mentioned that the property was previously a holiday home for more than a decade. Does that mean a rented kind of holiday home? And would that make a difference if it was, or within this application?
Thank you, councillor. For the property to be accepted, or for the lawful use of the property to be accepted as a short-term let, the applicant would need to demonstrate that that has been the case for at least a 10-year period, and that period has there's been no intervening use, and that forms a planning application, and the information that's submitted is assessed by the planning service as to whether that demonstrates that the use of it as an STL would have been lawful for at least a 10-year period, and would include certain types of information, evidence of lettings, for example, or any other certificates or so on that they may have.
And no indications being given that they're pursuing that in any way.
Not as far as I'm aware. I think they've been unable to establish, since they've taken ownership of the property, that they could gather sufficient evidence to demonstrate that 10-year period.
And the third question, that maybe more legal, I don't know, but or interpretation of the policy, regarding that we've now seen that there's another short-term let property within the same block, and one of the reasons for refusal is to protect the residential amenity or the residential area, but given, and I am assuming here that that property has been through a planning permission previously. How does that affect us when we're making a decision, given that there is already a commercial property within the same block, where you're then not protecting the integrity then of, or the integrity of a residential block or a residential area has already been set.
Yeah, thank you, councillor. The other property in the block that is operated as an STL and is lawfully operated as an STL, that was obviously through an application for a certificate of lawfulness, and those applications are not assessed against planning policy in the same way. It's purely based on it's a legal process that's administered through the planning process, if you like, where the information that's submitted in support of that application would be assessed by the planning service, and the planning service would decide whether they agree that the use is lawful, which they've obviously done in that case. The difference here is they've been unable to pursue that. They've had to go down the route of applying for a planning permission instead.
Is there any then advice to give to us then, given that we cannot predict? Sorry, convener. Given that we're making a decision on something, you know, where we're trying to, one of the core elements is to protect the residential area, but that's already been, you know, through a different means been set. What should our guidelines be as far as policy goes in relation to that?
Leslie Mr. Dooner may wish to comment as well, but I think it is a material consideration that you have to weigh up along with the other considerations. So it may not mean that you have to grant or you have to refuse, but it's part of the overall picture from which your ultimate decision is taken. If you feel that the preservation of residential has been compromised and it's not going to be substantially more compromised by this one in addition to the one above, you may be more inclined to support the application, or you may feel that what has happened because it didn't have to be assessed on its merits as a planning application, and that's not of sufficient weight. It just has to be assessed by a decision maker. I don't know if Leslie wants to add to that.
Thank you. That's helpful.
Councillor James, have you any questions?
I think everything's been asked, to be a fair convener. Thanks.
Okay, thank you very much. Members, can we proceed to determine the application for review on the basis of the information before us? That is, the information contained within the papers and the presentation by the planning advisor, or do we require more information? Councillor Waters?
Happy to proceed.
And Councillor James?
I'm also happy to.
And I'm too happy to proceed. So Councillor Waters, over to you on this one.
Yeah, I think, you know, initially certainly looking at this as I was, you know, very keen to kind of protect the residential area as in line with the policy. But, you know, I do feel, given that there is already a single let property within the building, within the block, I would be minded to you know, accept the appeal and allow the STL to go forward, mainly just because the difference, you know, if there wasn't already a property within the building, I would probably minded to refuse it. But given that there is already one, I feel the difference between the loss of amenity and protecting the residential area is very much diminished. So I will say that we pass the application. Thank you.
And Councillor James?
Yep, thanks, convener. And like Councillor Waters, I think the fact there's a hostel in the area, you know, the residential amenities already been breached, if you like, and I don't mean that in a detrimental way. But that, along with the fact there's the upstairs property is already an STL, and this one has been used as an STL, I have no problem at all with accepting the appeal. Thanks, Convener.
Thank you, councillor. I too, I think I'm going to be prepared to grant this one. It's away from the mixed use area, it's a residential area, but there is a hostel nearby, which means there's a movement of people. There's 4 flats in the block, of which 2, including this one, will be STL properties. I think that's a material consideration. But the main point is, of course, there's a separate entrance on this one. So there's very little effect on the other flats. And as we said, there's already a movement, an existence, a track record of STLs in the area. So I too, I think I'm prepared to grant the appeal on this one. So Mr. Fogg, we have a unanimous decision on this one to grant. Okay. Right. So members, we'll now move on to item 4.6. Now, once again, a short-term let, change of use. This is in Burnside in Aberfeldy. Now, I've noticed on this particular paper, the decision notice was issued on the 31st of October, and obviously the paperwork predates that. The non-statutory guidance was on the 1st of November, and I appreciate they're virtually on the day, but to be consistent, I think once again, we should defer this case. I think for the planning officer to review it again in light of non-statutory guidance, then allow the applicant, I think is with us, to have a chance to comment on that decision. And then obviously it comes back to development management and then back from them to us. So if you're both agreed, I propose to defer this one. Let's save Mr. Tierney's voice and go through it all. Councillor James, are you happy with that?
Yep, very happy.
And Councillor Waters?
Yes, happy, Convener.
Thank you very much. So another deferment there, Mr. Fogg, this one, just for their comment, I think, which is only fair given all the deferments we've made already. So it's the right way to proceed. Members, this now brings us to the next section of the agenda, which is 4 cases which have already been deferred, coming back to us. It had been my original decision perhaps to have a short recess, but we've only been an hour, so I think we'll just keep going on. So the next item on the agenda is number 5.1. Change of use of flat to a short-term let accommodation unit in principle at 21 Rayburn Park in Perth. As I say, this has already come to us and been deferred because of the dates. So Mrs. Tierney, if you could just introduce this one back to us. Thank you.
Thank you, Convener. I will just run through the slides. I'm unsure from previously whether you've seen these or not before, but anyway, this is the aerial image of the location of the property, which is highlighted with the yellow star there, so you can see proximity to the railway station there, but also that this area is very much residential. Next slide, please. This is the actual property itself. So as you come into Rayburn Park, the flatted building there with the part of the building where this flat is located highlighted there in red round about it. Next slide, please. And then this is the site plan showing the wider area. The site outlined there in red, which includes the footprint of the flat and the associated parking and access and bin storage areas as well. Next slide, please. And then this is just a closer image to show you where the property is outlined in red and the associated parking and visitor parking. Next slide, please. And then this is the floor plan of the property. 2 bedrooms, lounge, kitchen, bathroom area, and the entrance in from the communal access on the ground floor. Next slide, please. This is the, as you approach the property from the internal access road, this is the front of the building. The appeal site is round the back. We'll come round to that, but you can see the nature of the property here. 6 flats in this part of the building. Next slide, please. And then as you come round the side, you can see the other residential properties neighbouring the site. Next slide, please. And then this is effectively around the back of that first image where you see the other part of the development at the back of the property with 3 flats there with their own access door. And the flat is the ground floor flat. So the bay window, the windows either side and the access door just in the corner there. Next slide, please. And then a closer up image of, again, the ground floor flat, bay window, and the communal access door. And then this is the parking area that goes along with the appeal site. Okay. So yes, the consideration of this appeal was deferred at a previous meeting to allow the planning service and appellant to comment on the council's short-term let planning guidance, which had been adopted after the appeal was submitted. The appeal site is at 21 Rayburn Park, which is a 2-bedroom ground floor flat within a modern 3-storey flatted building containing 9 flats in total. And the flat is the ground floor flat below 2 other flats in this part of the building. The entrance to the building is via a communal door leading to the 2 other floors. A reminder of the reasons for refusal. Firstly, that the proposed retrospective change of use is contrary to policy 30 tourism E of MPF 4, as the proposal will result in an unacceptable impact on local amenity and character of the area, and the loss of residential accommodation where such loss is not outweighed by demonstrable local economic benefits. 2, that due to the shared entry arrangements and the flatted nature of the property, the proposal would result in an increased potential for noise, nuisance and general disturbance to occur that would impact adversely on the character and amenity of the local area, particularly the residential amenity of those living permanently in the residential block. And the proposal is therefore contrary to MPF 4 Policy 14C, Design Quality in Place, and Perth and Kinross Local Development Plan 2, Policies 1A and 1B, Placemaking, and Policy 17D, Residential Areas, which all seek to safeguard residential amenity and ensure that proposals contribute positively to the surrounding environment. The further assessment by the planning service noted that the guidance places more emphasis on the nature of the area where the short-term let is situated. Specifically, within a predominantly residential area, could there be an adverse impact on amenity for existing residents, particularly in blocks with shared and communal entry? And they add or conclude that this consideration supports the original reasons for refusal. The applicant, in this case, has commented that they have proved that there would be no unacceptable impact on local amenity or the character of the neighbourhood or areas, and the loss of the residential unit would be outweighed by demonstrable local economic benefits. This is because it is clear from the time the STL has been operating that there has been no impact on local amenity and no objections from anyone, including immediate neighbours. The flat is rarely empty and visitors are using the flat for visiting local events and attractions. It is further noted that the flat would not impact on the number of short-term lets in this area of Perth as confirmed by local housing, and there are no objections from environmental health. They go on that the location of the property is located close to public transport, has its own parking space and is within easy walking distance of the city centre. It is also stated that consideration should be given to Policy 17D of the LDP, which encourages business, home working, tourism or leisure activities. And just in terms of other matters, as noted there, environmental health has no objection and the property would be subject to normal licensing conditions. The community's housing strategy has indicated that the level of STL within the local postcode area is not at the level where a control area would be considered. Roads have no objections and there are no letters of objection from third parties.
Thank you. I'll open up to questions. Councillor Waters.
I don't really have any questions, any further questions on this one. Thank you.
And Councillor James.
Yeah, thanks, Camilla. Just the one, actually, if I could, the door you showed at the back of the property, adjacent, it was in the corner. Does that go directly into the property in question? Or does it go into other areas? Sorry.
So here we go. So there are 3 flats, ground, first and second floor in this bit of the building. It is a communal door to all flats.
Sorry.
Okay, well, you've actually asked my question now, so that's me out of questions. So members, can we proceed to determine the application for review on the basis of the information before us? That is, the information contained within the papers and the presentation by the planning advisor, or do we require more information? Councillor Waters
Happy to proceed.
and Councillor James.
And likewise, convener.
And I too am happy to proceed on this one, and I'll start on this one if I may. It is and I visited the site when it first came around to us. It is a residential area, and it was built as a residential area, and that was the spirit of the building of it. And a short term that is effectively a commercial operation, and that will be a commercial operation within a truly residential area, as we can see from the photograph. As we mentioned before, and I think it came up in the comments here, a material consideration has to be the appeal that was sent to the Scottish Government. It's an important part of assessing these applications. Although again, a different area, the concept that still applies here. As mentioned, been made about in the refusal about policy 17D, and that does encourage development, but it does make it clear that it must be compatible with residential amenity, and that is the core of all of these, and that is the residential amenity and the character of the area. We've also heard mentioned that there have been no complaints, no objections, and the appeal does make it clear that impacts on amenity and character are not limited to recorded instances of any antisocial behaviour or any complaints. Taking into account the various elements of that appeal, and predominantly the intensification of movement of people coming and going, that would change the amenity of the area. And I'm of the opinion, therefore, that in this instance, bearing in mind that there's a truly residential area, to refuse the appeal. Councillor Waters.
I have nothing to add to what you said, but I do agree that my decision would be to refuse the appeal.
Thank you. Councillor James.
And I think I agree with the pair of you as well, convener, for all the reasons you've mentioned. Thank you.
Thank you. So, Mr. Fogg, we have a unanimous decision to refuse. Okay. Thank you. So,
Convener, sorry.
Sorry.
Does the reason for refusal, I think, refers to 1B again? Just for noting.
yeah, you're quite right. It does. So that, I think, Mr. Fogg, that should be eliminated from the number 2 reason for refusal 2. It isn't really 1B. Full agreement with that, I think. Yep. Okay, fine. Thank you. So we'll now move on to item 5.2, which is another previously deferred case that's coming back to us. This is a change of use of a flat to form a short-term let accommodation unit in flat 4, 38 Bonnet Hill Road, again in Pitlochry. Mrs. Tierney, if you could give us an introduction on that one.
Thank you, convener. Yes, so in this case, here we go again, back to Pitlochry. The yellow star indicates the location of the appeal property. As you can see, the main road through Pitlochry there with Bonnet Hill Road, carrying on up to the north towards Toberargan Road. I suppose the main thing is it is closer to the town centre of Pitlochry rather than the residential area as you move up Bonnet Hill Road. Next slide, please. And then this is the appeal site, just highlighted there in red, so you can see exactly where it's located. Next slide, please. This is the site plan that goes with the application and appeal, which is the layout of the flat itself around the footprint of the flat, and then the access to the property off Bonnet Hill Road and the car parking space at the rear of the property. Next slide, please. And then that's just zooming in a bit closer on that, so you can see where the access comes in and comes round to the back of the property with the parking space. Next slide, please. And then this is the front view of the property there with the it is subdivided. I'll come on to that in the presentation. First floor, 1-bed flat with a communal entrance and stairwell there. So it's the first floor flat as you look at that elevation. Next slide, please. And again, this is the property itself. Next slide, please. And this is just kind of as you zoom out and you can see what's round about. So a lot of these properties are not residential. They're more commercial in nature or hotel type accommodation as you move down towards the middle of the town centre. Next slide, please. And then this is as you look back down Bonnet Hill Road, appeal property on the left-hand side there. Next slide, please. And then this is round the back of the property where the parking is located. It's not really defined in any way, but that's where the car parking is. Okay. So yes, consideration of this appeal was deferred at a previous meeting to allow the planning service and appellant to comment on the council's short-term let planning guidance, which had been adopted after the appeal was submitted. So yes, as a reminder, the appeal property is a first floor, 1-bed flat accessed via a communal entrance and stairwell, and it's located within Pitlochry town centre. The planning service has further commented that the STL guidance acknowledges that while short-term lets can bring economic benefits to the host and local areas, this must be balanced against the impact the loss of that residential property has on the availability of housing for local people, affordable housing in particular, and the potential for adverse impacts on residential amenity, where an increased proportion of the housing stock becomes short-term lets. The 6 considerations outlined within the STL guidance to assist in the application of the policy framework set out in NPF 4 include location, larger residential properties, refurbishment of long-term empty properties, local amenity and character, business diversification, and the relationship between loss of residential accommodation and local economic benefits. The location consideration contains reference to 3 area types: city and town centres, mixed-use areas within settlements, and predominantly residential areas. The site is within Pitlochry town centre with its associated mix of uses and levels of activity. The effect of the proposal on local amenity and character of this area should therefore be considered, in addition to the loss of residential accommodation and local economic benefits which may accrue from the proposal. The guidance indicates that town centres may well be suited to the introduction of short-term let accommodation in terms of residential amenity and the area's character. In this instance, the flat is within Pitlochry town centre, and whilst the flat is accessed via a communal entrance, this itself did not form a ground for refusal due to the existence of a previously approved short-term let accommodation unit on the ground floor of the building at 38 Bonnet Hill Road. With regard to the loss of a flat to short-term let accommodation in an urban location, it is also acknowledged that Housing Strategy have undertaken consultation in respect of the introduction of a short-term let control area. However, no such control area has yet been formally designated. Whilst the assessment of this policy criterion for the application as originally submitted referred to a postcode district level of saturation of potential short-term lets, it has since been considered that a more up-to-date analysis of the proliferation of short-term lets in the area, including but not limited to recent licensing data, requires to be undertaken before the Council as Planning Authority decide whether to progress with the designation of an STL control area. In this instance, given the town centre location of the proposal, it is considered that the loss of this 1-bedroom flat in the town centre to short-term let accommodation would not have a significant impact on the availability of residential accommodation in the local area. And whilst the economic benefits associated with the proposal are likely to be modest, this no longer constitutes grounds for concern in this instance. Therefore, had the proposal been submitted after the 1st of November and the adoption of the guidance, it would likely have been recommended for approval, subject with 3 conditions, including that the permission will only last for 3 years and the property shall not be occupied as the sole or main residence of any occupant. So the only other things I was going to mention was that environmental health had no objections. There were no objections from roads and no objection from planning due to public transport and parking close by, and there are no third-party objections either. Thank you.
Thank you. We go to questions. Councillor James
No, I've no questions, thanks, convener.
and Councillor Waters.
No further questions.
Thank you very much. So let me get my piece of paper here again. Members, can we proceed to determine the application for review on the basis of the information before us? That is the information contained within the papers and the presentation by the planning advisor, or do we require more information? And Councillor James
No, very happy to proceed.
and Councillor Waters.
Happy to proceed.
That's fine. So Councillor James, if you could start off for us on this one.
Yeah, thanks, convener. And it's really nice, actually, the planning officer's comments. It's good to see, you know, where this one's been deferred back and he's made comment. And his summing up of the last paragraph says, you know, this proposal would likely have been recommended for approval. That's what I was looking for, if I'm honest, convener. And to that end, rather than go on and on, I'd be more than happy to accept approval of this. Thank you.
Thank you, Councillor. I too am happy to proceed, and in this instance, the planning officer's done all the work for us, really. So it makes it a lot easier on this occasion. It wasn't annexed to the hotel anyway, and I think one other flat was already at STL. I understand maybe another one may not be only occupied as such on a regular basis. So I'm happy to grant the appeal on this one. Councillor Waters.
Likewise, unanimously happy to grant the appeal for this one. It is already a commercial area. We're not trying to protect any residential area here, so happy with the unanimous decision on that.
Thank you. Mr. Fogg, another unanimous one this afternoon, sorry. So that's good. That's good news. Members, we'll now move to council. It's not contentious at all today, is it? We'll move to item 5.3 now, which is a further case that was deferred previously. This is the siting of 3 accommodation units and a laundry storage unit for use as short-term letting or workers' accommodation and associated works in retrospect. And this is on land 170 metres north-east of Keeper's Cottage, Amory in Dunkeld. Mrs. Tierney, if you could start us off again, please.
Yes, thank you, convener. So there's some images here of the application site, and just this is the general location of the application site, just to the north of Amory, as you can see there. Next slide, please. And then on an aerial image, you can see the rural nature of the area there, just to the north of Amory, with the site indicated with the yellow star. Next slide, please. And again, as you come a bit closer in, you can see the main access road to the property, leading north there from Amory, and just leading off the road there up through existing other farm properties and farm buildings, carrying on up the track to the application site, indicated by the star. Then this is as you look at it again with the actual site outlined in red, caravans and a storage unit there, and we'll come a bit closer into that now. Next slide, please. So this is as you look at the entrance that leads you up to the application site from the main road, so very rural area, rural buildings, and so on. Next slide, please. Then as you carry on up the track, this is the plan that's the existing caravans on site, 3 of them there, and then the small container that's part of the application as well, just down in the bottom left-hand corner there of the red line application site. Next slide, please. These are just the elevations. The caravans are existing, so these are the elevations of the caravans, and then also the small container unit again at the bottom there. Next slide, please. Then as you come off the main road and past the buildings, this is as you head up the hill effectively towards the application site. Next slide, please. And then this is the site itself with the 3 existing caravans and also the container there with the welfare laundry unit. Next slide, please. This is just a closer up image of one of the caravans that are on site. Next slide, please. And another one. Next slide, please. The final one. Next slide, please. And then this is the container unit at the front of the site. Next slide, please. And just as you turn round to head back out of the site through the access there back onto the track down to the main road. Next slide. Then this is as you head back down onto that track down to the main road. And again, as you carry on further down towards the existing buildings beside the main road. And a view which would be southwest direction, I believe. I think that's us. Okay, so just to kind of go through the appeal again, it was obviously deferred at a previous meeting to request further information in the form of a business plan as per the requirements of LDP Policy 8, Rural Business and Diversification, including a monthly breakdown detailing seasonal worker versus tourist use of the accommodation, which the planning service would then provide further comment on in terms of its assessment. So as a reminder, the caravan site was established about 5 years ago on the basis it was for temporary accommodation for seasonal workers in line with the General Permitted Development Order and the Caravan Act, and that the application was made to regularise continued use of the caravans for short periods of time, either by seasonal workers or by short stay visitors. There's also a separate laundry and washroom in the container, and that has no permitted development rights or permission, and is part of the application. The reasons for refusal were as follows. 1, that the proposal is contrary to policies 14, Design Quality in Place Part C, and 29, Rural Development Part B of MPF 4, and placemaking policies 1A and 1B, Parts B, C and D of the Perth and Kinross Local Development Plan 2, as the development does not respect the character or amenity of the place in which it is located. The development lacks an established landscape framework and is purely related in terms of form, design or layout to the existing buildings or surrounding environment. It would, as a result, appear visually incongruous and out of keeping with the wider landscape setting. 2, that the proposal is contrary to Policy 29, Rural Development of MPF 4 Part A, and Policy 8, Rural Business and Diversification of the Perth and Kinross Local Development Plan, as the proposal does not relate to the expansion of an existing business and fails to demonstrate that the site presents a site-specific site resource or opportunity. The proposal has also failed to satisfactorily demonstrate how it would improve the quality of new or existing tourism facilities, allow a new market to be exploited, or extend the tourism season, or that the development can be satisfactorily accommodated within the landscape capacity of the site. And then 3, that the proposal is contrary to Policy 30, Tourism of MPF 4 Part B, and Policy 9C, Chalets, Timeshare and Fractional Ownership of the Perth and Kinross Local Development Plan. The proposal would not involve expansion or replacement of existing tourist accommodation, would be remote from sustainable transport options, would not be compatible with the surrounding area, and it has not been satisfactorily demonstrated that the proposal meets a specific need by virtue of its quality or location in relation to existing tourism facilities. So the applicant has further commented that they've provided and prepared a business plan, which includes a monthly breakdown detailing seasonal worker versus tourist use of the accommodation. They seek to obtain permission to use the caravans as holiday lets when they are not being used for workers. The expectation is that the caravans would be used around 120 nights per year, which is a total for all 3 caravans, and that allowing this use will generate income for the applicant and encourage local employment and bring benefits to the local economy. The applicant operates a farming, sporting and property business employing 9 full-time and 3 part-time staff, and there are times such as lambing, beaters, labourers, chefs, cleaners who use the caravans at different times due to the remote nature of the area and the lack of public transport. And out with these times, the intention is to allow the caravans to be used as holiday lets for periods of time. The applicant already successfully operates a short-term lets cottage on the estate, and this would add to this offering. The infrastructure is already in place at the caravans, and the site is self-contained within the land owned by the applicant, and the use will not detrimentally affect wider land use. The expected profit and loss for the caravans over a 12-month period is detailed, and it is noted that income will depend on when the caravans will actually be able to be used for holiday lets. The applicant states that Policy 8 may allow for rural business and diversification in rural areas and out with settlements where they offer opportunities to diversify an existing business or are related to a site-specific resource or opportunity. While the proposal does not specifically relate to the expansion of an existing tourism business, it would strengthen income for the estate business and resourcefully make use of existing accommodation when unoccupied. It is stated that the units already exist and are not visible in the landscape and will be mitigated by landscaping. As the caravans are there already, under permitted development, they do not result in suburbanisation, and because they are small scale, they do not cause significant unsustainable travel patterns. Their location is remote from other private properties. The planning service has reviewed the information which was submitted by the applicant and remains of the view that the location of the site is physically and visually isolated. There are concerns about the fact that the use for workers is dubious. For example, is there a need for 3 caravans and appropriate work to support this? And that this also means that the amount of time they can be used for holiday accommodation could be far greater than stated. It is reiterated that the lack of information provided for this application when it's submitted remains disappointing, and notwithstanding the information which has been provided, the location of the site is not appropriate from a placemaking or landscape perspective. Thank you.
Thank you. We'll go to questions. Councillor James.
No questions from me, thanks.
Councillor Waters.
Thank you, convener. Just in, it is quite a bleak landscape, and it really is. The caravans don't look like they're very well contained within the landscape. The initial application you mentioned has the part of the application was to do some planting of some native trees. Do we have any idea to what the extent of that planting would be, or would be as proposed within the application?
Yeah, councillor, not any more than what is shown on the plans that were submitted with the application. If we can maybe go back to the site plan in the presentation, you'll be able to see. So you can see kind of to the southeast of the site and then to the north of the site areas of planting, which could obviously be secured by planning condition.
And there was no further detail. There was no further detail given on the type of planting. I mean, I do recall reading in the papers it was native trees that they were looking at planting. Right. Thank you.
Councillor, question just on the caravans and this what you describe as a welfare unit. I mean, presumably the caravans themselves are self-contained with all the necessary facilities. I just wonder what this welfare unit's there for. Do we have any idea what it's there for?
convener. I think it was for laundry purposes.
Thank you. That's my only question. So members then will proceed as always. So members, can we proceed to determine the application for review on the basis of the information before us? That is the information contained within the papers and the presentation by the planning advisor, or do we require more information? Councillor James
Happy to proceed.
and Councillor Waters.
Happy to proceed.
I too am happy to proceed. So Councillor James, and that's your ward. So would you like to start us off on this one?
Yeah, thanks, convener. It's in really nice part of my ward, actually. I love it at Amelry. Yes, it's how we interpret the rules, and I take the point in there, the appeal by the applicant about an expansion of an existing business. I suppose in effect, this would allow the expansion of an existing business. We're asking, farms and everything to diversify, and this would give them that little bit of diversification. The units have permission to be there, so if they're there, why not put them to use and let them get an income from them? So I think it's an expansion of an existing business. Being incongruous in the landscape, yes, perhaps they are, but only when you stood in front of them. And I know normally we like to have defined boundaries, we like to have tree planting in place, but the fact is they are in place, and tree planting is, as you can see from the plan in front of us there, convener, is planned anyway. No objections from the general public, and you can't see this from anywhere other than in front of it. The whole area is used by walkers, out through across the moor there at Amelry and out through Glenquay, out towards Kenmore. So, as far as transportation and what have you, yes, okay, you'll need transportation to get out there, but I would imagine that it's one of those locations where people are going to go for that type of holiday, where they will walk. So for all of those reasons, I would actually allow the appeal and grant permission to use them as short-term lets, convener. Thank you.
Thank you. Councillor Waters.
Thank you, convener. I was hoping you might go first there, but your prerogative there with that one. We're looking to, definitely policy allows the economic diversification of businesses, and I think that's absolutely essential. And these caravans there are already permitted development, and but it isn't contained. I think it's hard. I'm trying to imagine with the trees planted whether that makes it contained, and I'm not 100% convinced. Two little clumps, in separate corners. That does it. I am struggling to imagine what that would look like. And I do know officers, and some of the comments that I was reading in the papers, I do believe there might be better areas within the applicant's ownership to where it could be more enclosed. And I have to say I do tend to agree with this. Maybe if there was more tree planted around this or more something to create that more contained look, I may be different. I am inclined to refuse the appeal on this one, but not the principle as such. I think with potentially, as officers have said, if it was a different location, or something else needs to be done in there to create a more contained, to allow it to be more contained within the landscape, the development. So on that basis, I will go for refusal of the appeal.
Thank you both. So that leaves the decision on me. Casting vote. Thank you very much. You never go last. That's the thing. So if I've got the casting, let me be up front. My feelings on this one is to refuse. The caravans are in situ purely on permitted development. If it wasn't for that, my feeling reading the papers and reading the comments of officers, it would never have been approved in the first place. I appreciate the comments Councillor James made that you can't see the caravans from the road. I know you can't see them from the road. But I still come back to this point that they are only there because of permitted development. We did defer this for more information, which I appreciate we've got. I don't take any comfort from the report we've had. Given that circumstance, my thoughts on this are really, as I say, to refuse. On the basis of the comments and the reasons for refusal given by the planning officers, and also, of course, the information that the officers have commented on and have seen the business plan, but they're obviously not happy with it. I feel in this instance, as I say, there isn't the comfort there for me to override the original decision. So on this occasion, I'm going to refuse using the same reasons for refusal as the officers originally put. So Mr. Fogler, again, we have a majority decision on this one. Anything else from that one? You're happy with that? You and I both refuse. Yeah. Okay. So members, we now turn to the last application of the day, which is item 5.4. This is another referral that's come back to us again. This is the starting of a holiday accommodation unit, formation of vehicular access and parking area, and associated landscape in land 30 metres southeast of Fairy Green Cottage in Kinross. So, Mrs. Tierney, if you could introduce that one for us.
Thank you, convener. Let's run through the slides first. So this is just to give you the context of the location of the appeal site, which is located there with the yellow star. So you can see Invergowrie to the west of Dundee there, the A90, and then Socher being the nearest village. Next slide, please. And then this is just starting to zoom in on the location of the appeal site in relation to Socher there in the top corner and Fairy Green Cottage. Next slide, please. And as you come into the application site itself, existing farm buildings and the appeal site shown outlined in red there next to Fairy Green Cottage, which is just to the immediate west of the appeal site. Next slide, please. And these are the plans that were submitted with the application. So you can just make out the red square there of where the application site is located. Next slide, please. And then as we come into the actual site itself, outlined in red, the existing Fairy Green Cottage in the same ownership to the top side there, and then the indicative layout for the holiday unit within the red line. Next slide, please. And these are just some images of the elevations of the proposed holiday unit. Next slide, please. And then these are some kind of 3D images of the elevations and the interior. Very small building. Timber, walls wriggly tin and glass. Next slide, if there is. And then this is as you head off the main road up the track towards the existing buildings, with the site on the left-hand side of the screen here. And then next slide, please. And this is the site here, contained paddock area with some existing planting and hedging and fencing round about. Next slide, please. And then this is looking back in the opposite direction, back towards the main road with the existing cottage on the other side of the appeal site. Next slide. And then this is as you look back up the track to the main road past Fairy Green Cottage. And then again back to the site itself. And then this would be the view across from the appeal site into the neighbouring land. Okay. So yes, this proposal is for a new timber-clad holiday cabin on a countryside plot adjacent to Fairy Green Cottage to the northwest and the existing farmyard and buildings of Fairy Green Farm to the southeast. The site would be accessed via an existing farm track from the C440 public road to the northeast of Collis. The site lies in an area subject to reduced transport contributions whereby payments are required in respect of transport infrastructure, and this is required prior to any permission being issued. So the application was refused for the following reason: that the proposed holiday accommodation is contrary to policies 13 Sustainable Transport Part B, 29 Rural Development Part B and 30 Tourism Part B of MPF 4 and policies 8 Rural Business and Diversification, 9C Caravan Sites, Chalets and Timeshare Developments, Chalets, Timeshare and Fractional Ownership, and 60B Transport Standards and Accessibility Requirements. New development proposals of the Perth and Kinross Local Development Plan 2. The proposal fails to meet the relevant criteria for countryside development to be justified, promotes unsustainable travel patterns by virtue of its remoteness from public transport options, and fails to meet a specific need by virtue of its quality or location in relation to existing businesses or tourist facilities. The refusal of the application was fundamentally based on the view that it was unclear how the proposal constituted a site-specific opportunity, that there was no indication that the sporting offer of the estate would take place close to Fairy Green Farm, and it is considered that the proposed site is too remote from existing tourism and other amenities, and as such is unlikely to allow a new market to be exploited or extend the tourism season. As we've heard, the appeal was deferred to request further information in the form of a business plan. So the applicant has submitted a business plan which seeks to demonstrate that there is an opportunity to develop a high quality tourism enterprise at Dunsinane Estate, as it has been recognised that there is a requirement to diversify their largely traditional farming practices in order to ensure the estate remains viable for future generations and so it can continue to play an important role in the local community. Analysis of existing holiday accommodation in the area shows that the location is considered to be a key attribute, and people who come to stay at Dunsinane will be able to experience a variety of historical landmarks, walking and cycling, and with various places to eat and drink nearby. While it is noted that the car is the most popular mode of transport for visitors, the applicant will include secure bike storage, and guests will be offered free collection from the nearest bus stop. The Perth Tourism Action Plan is quoted along with various other documents and initiatives which would lend support to such a proposal. It is highlighted that this proposal is the first of 4 planned units that the estate has identified to support their plans for high quality accommodation in an environmentally conscious manner. The site is next to Fairy Green Cottage, which is already used for short-term holiday accommodation, and the feedback on the location is very positive. In terms of social, economic and environmental benefit, the tourism side of the business will support 5 full-time equivalent jobs, presuming all planned holiday units come to fruition, and financial figures are quoted that the business will generate that the business will generate for the local economy. And again, that would presumably be again once all the units are in place. So in response, the planning services commented largely on the other proposed accommodation proposals the appellant has been or will be looking at to pursue on their estate land. But they do remain concerned that the location of this development is being described as sustainable and that the site is not readily accessible by means other than the private car due to the nearest operational bus stop being in Soccer itself. Thank you.
Thank you. Go to questions, Councillor Waters.
Thank you, convener. The ideas of the sustainable transport in a very rural area where we're already struggling with any buses or stuff like that, would mean nothing would happen in some of these rural areas, and sometimes it's a chicken and egg. Maybe have people that would use sustainable transport might create the impetus to get more sustainable transport there. But I think there's a question in here somewhere.
I was going to ask.
Thanks for your patience with my convener. How, you know, that policy, the material weight for that policy, given it is already a rural area and unlikely to have a bus service in this day and age, how much weighting should we, or would you say, as we should be putting on that policy?
Don't know if Mr. Fogg maybe wants to come here as well. I think it's I think my role is really to say, I think that's up to yourselves, councillors, I'm afraid, to decide how much weight to place on particular parts of policies.
Yeah, I was going to give a not dissimilar answer to that. Councillor, I do try to be helpful, as you know, but it is part of the development plan. So it's been considered and accepted by Scottish ministers prior to the adoption of the LTP2, and it is definitely a material consideration in council policy to which you're expected and required to have regard. You don't have to slavishly adhere to it, or policies can be departed from, but it is currently, until LTP3 comes along, is part of the development plan.
Thank you, Jeff.
After this more discussion, I'm very kind to you, Councillor Waters, but then you waffle. Councillor James, any questions?
I think the only question is, convener, to follow on from that, is there a bus service out there at the moment, and is there likely to be a bus service out there? No questions. I'm being very flippant. Sorry.
It's the end of the afternoon. I have no questions either, but most of the questions were asked on the last time around. So members, can we proceed to determine the application for review on the basis of the information before us, that is, the information contained within the papers and the presentation by the planning advisor, or do we require more information? Councillor Waters?
Happy to proceed.
And Councillor James?
And me, convener.
And I'm too happy to concede, continue. So, Councillor Waters, your comments.
Thank you. Rural transport and the issues around that and sustainable transport, I won't comment on, but I think it is certainly a challenging area going forward. And I'm minded to actually grant the appeal on this one. I think there is a need and requirement to allow businesses to diversify their income within that, and this seems a reasonably modest development where there are already economic activities going on, and a few houses and three houses within it. I feel that it's a well contained area. It certainly, looking at the plans and the amount of work that's gone into it, seems to be a high quality development. Given the size of the units are quite modest, I think you would struggle to take more than one car travelling to it and back from it, given it's just a double two person lodge. So I have no problem going with the appeal.
Thank you, Councillor. I'll come in next if I may. A lot of the decision here was to do with sustainable transport. I quite understand the point, but we want to have economic development, whether it's urban, suburban or rural, and we can't constantly stifle that. If we want to, we can't stifle it because you've got to drive a car to get to it. Rural areas are what they are. and businesses need to expand. And there's a very valid point in this, in the actual business plan, which mentions that the experience economy is growing. Travellers no longer look for tourist products, but they want experiences. I think a lot of people going to places here and other places like this want to go to experience going back to nature, if you want to put it that way. Get away from mobile phones, from everyday life, and just enjoy it. That's not to say people won't, arrive in a car and go out for a meal somewhere, but I don't see them going out constantly driving all over the place. They'll be there to enjoy the experience of being around nature, especially if there's children around will want to see animals and be on a farm and see the land itself. So I think the idea that because you've got to drive a car to get there is not really a solid ground to refuse it. So I'm of a mind to grant the appeal. I think it's the business plan is very supportive of it. Having driven there and seen it, I think it's a good location for this. I don't see any problems. And obviously, you're in a rural area. You've got to drive to get there. I appreciate they're going to put cycle storage there as well for people who want to use their bikes once they get there. But I think overall, I think it's a good idea, and I'm happy to support it. So I'm going to grant the appeal. Councillor James.
Well, unanimous and convener, because like the last application, I think this, this sustainable transport issue, I don't think is an issue, because people will go, they'll have to drive there. People will use the motor car and they'll get there. But because of its location, I think they're choosing that location for the peace and tranquility. So, I'm very much in favour of diversification of business. Like you say, it's a small development, which I don't think is going to hurt anybody or have any impact anywhere else. So I'm totally in agreement with the appeal.
So, Mr. Fogg, we end on another unanimous decision today. Nothing contentious come up at all. So that, I think, brings us to the end of the agenda. Members, may I thank you for your contribution. Mr. Tierney, thank you for all your work you've put into this one. Thank you, Councillor Waters, Councillor James, for your work. Thank you all. My only apology is to planning officers, because we've deferred 3 cases for them to do a review of those, but hopefully they won't take too long. And with that, we'll close the meeting. Thank you very much.
Cheers.